Mr. Hitchcock?
Um,
Oh, sorry, you're muted.
Hello.
Hello.
Hi.
Hello.
Clifton Hitchcock, Smith Stack Levine yeah.
So we have, the judge isn't out yet.
Well, I just wanted to ask a question
Sure.
if I should join the meeting room for our firm that's set up or wait to be asked to join.
Yep, just wait. I made you, excuse me, I made you co-host. But the judge will come out and address you, and then I think we're gonna watch a video, and then you can
Okay.
go.
Great.
Okay,
Thank you.
sure.
Is there a court clerk or the court officer?
Yes, sir.
Hi, I'm checking in for a case. I was wondering if I can call back in about 10 or 15 minutes.
The court is going to lock the Zoom hearing at 9:15, so if you're back before then.
Well, okay, if that's the case, then I'll just stick around.
Okay,
Thank you.
you're welcome.
It was a bunch of trash and I had somebody come.
Good morning. Today is Wednesday, April the 24th. I am Judge Martin. This is courtroom number 1. Today's docket is landlord-tenant cases only. If you do not have a landlord-tenant case, you are in the wrong courtroom and staff will help you get where you are supposed to be. At approximately 9:15, there will be a short video that plays that explains the legal rights you have available to you today in this landlord-tenant case. After that video ends, every case that is scheduled will be called. When your case is called, you will be expected to have your video on, to unmute yourself and state your name for the record. After you have a chance to speak to your landlord's attorney, if you've reached an agreement, that agreement will be placed on the record. If you need another hearing date, that next hearing date will be next Wednesday, May the 1st. Until that time, keep yourselves muted. Thank you.
Yes. Cool.
Bless you.
Thank you.
Good morning. This is Judge Martin. This is Wednesday, April the 24th. This is a landlord-tenant docket. If you do not have a landlord-tenant case, you're in the wrong courtroom, and court staff will help you get where you need to be. In approximately 6 minutes, we will start to play a video that explains the rights that you have available to you this morning. After that video ends, every case that is scheduled will be called. When your case is called, you will be expected to unmute yourself, turn your video on, and state your name for the record. Tenants, if you wish to have the opportunity to speak to an attorney from Lakeshore Legal Aid, that will happen when your case is called. You will go into a breakout room, meet with the staff. Your case will be adjourned to May the 1st. That's next Wednesday. If you have filed a request for rental assistance, there is a form that you will need to submit to the court. There's court staff available to direct you to that form. If you are driving, stop driving. If you're smoking, stop smoking. If you're wearing a cap, take it off. Please leave yourselves muted until your case is called. Thank you. Mary Ann, would you start the video, please?
Yes, ma'am.
Welcome to the 34th District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have the right to hire an attorney to represent you. If you cannot afford to hire an attorney, you may qualify for legal aid assistance. There may be a representative from Lakeshore Legal Aid available today to speak with you, or you can contact them at 888-783-8190. You have the right to have your case heard in the proper venue. If the property is not located in the 34th District, you can ask the court to transfer your case to the district where the property, or any part of it, is located. You have the right to demand a jury trial. If you want a jury trial, you must tell the court today or make the demand in writing within 5 days of today's hearing. You can use Form MC-22 Jury Demand and file it with the court. You must pay $50 when you make your demand, or within 5 days of the court advising you of this right. You do not have to pay the jury fee if you have asked the court to waive fees and the court has approved your request under MCR 2.002. If your landlord has asked for you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, MDHHS, a local coordinated entry agency, a housing assessment and resource agency, or a federal Help for Homeless Veterans program. You should have received information on local rental and housing assistance with the summons. You do not need a judgment against you to receive help from the places listed above. A copy of the summons and complaint from your case are enough. If your case is for non-payment and you have already applied for assistance from one of these agencies, be sure to let the court clerk or the judge know when your case is called. You will be required to submit written proof to the court within 5 days of today's hearing. Your landlord-tenant case can be resolved in a number of ways. You may be able to reach an agreement with the landlord by going through a Michigan or local community dispute resolution program. You can find a program at courts.my.gov/CDRP. You may also reach an agreement with the landlord that will mean the case gets dismissed. A conditional dismissal is possible when approved by all parties. You can use Form DC-508, Consent Order for Conditional Dismissal, Landlord-Tenant, and file it with the court. Information about your other rights and the legal process is available through Michigan Legal Help at www.michiganlegalhelp.org. Additional information on legal resources, housing assistance programs, and court forms are available on our website at www.mi34thdistrictcourt.com/department/civil. Thank you for your attention. Your case will be called shortly.
This is 2402453LT Farmington Condo versus Mia Anderson.
Good morning, Your Honor. Grant Munson on behalf of the plaintiff.
Anderson? Ma'am, unmute yourself and state your name for me,
Okay,
please.
I'm sorry, Mia Anderson.
You're okay. Thank you. Ms. Anderson, have you made an application for rental assistance?
No,
Would you like to speak to a representative from Lakeshore Legal Aid this morning?
no,
Would you like the opportunity to speak to Mr. Munson, the attorney for Farmington?
Yes.
We'll get you moved into a breakout room with him. If you reach an agreement, you'll come back and you'll place that agreement on the record, okay?
Okay.
Thank you. 2402452 LT Capital Real Estate versus Michelle Berry. Please unmute yourselves and state your name for the record.
Michelle Berry.
Hi, good morning, Judge Ely Bijani on behalf of the plaintiff.
Good morning. Ms. Berry, have you made an application for rental assistance?
Yes, I have.
And would you like to speak to an attorney from Lakeshore Legal Aid this morning?
Yes, I would.
Ms. Berry, a few things will need to happen. Within the next 5 days, you'll need to complete and file with the court a form called a DC 539. You'll need to attach to that form proof that you've made an application for rental assistance. After you speak to Lakeshore Legal Aid, you will be free to go. Your case will be adjourned to May the 1st at 9 a.m.
Okay.
Notice
Your
will be
Honor.
mailed to you at the address. I'm sorry, did you say something, Mr. Bijani?
I just said thank you, that's all.
Oh, you're so very welcome, sir. You have a good day.
You as
Ms.
well.
Berry, you'll see an invitation to go into the breakout room with Lakeshore. Please go there.
Oh.
This is 2402451 LT Redford West versus Ronald Melville and all occupants.
Ready, Your Honor. Kevin Callahan for plaintiff, P78273.
Ronald Melville. Mr. Melville, you need to unmute yourself, sir, please.
I'm sorry. Can you hear me now?
Yes, sir.
Thank you. I'm kind of new at all this.
State your name for me, sir.
Ronald Paul Melville.
Thank you. Sir, have you made an application for rental assistance?
No, ma'am.
Would you like to speak to an attorney from Lakeshore Legal Aid?
No, ma'am. I have no money.
Mr. Melville, what you'll see is an invitation to go into a breakout room with Mr. Callahan that represents your landlord. Please go in there and talk to him. If you reach an agreement, you'll come out and put it on the record, okay?
Thank you. I don't know how to do that.
You're very welcome. You'll see something come on your screen and you'll need to tap it to get where you're going. This is 2402450 LT Metro Commons versus Fallon Dorsey and Tyree Dorsey. Please state your names for the record.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
Thank you. Fallon Dorsey or Tyree Dorsey? This case was scheduled at 9 a.m. It's now 9:23 by the court's clock. Defendants have failed to appear. The court will note there was mail by the court and posting by the plaintiff. Ms. Ellison, how would you like to proceed?
Your Honor, at this time, since there was that second mailing, I would ask for a default judgment. This was a just cause termination from a manufactured home. So we would just be asking for the 10-day statutory writ period.
Thank you, ma'am. Request for entry of default is granted. Please submit it through on base. Is there anything else this morning?
No, Your Honor, that is all.
Thank you, ma'am. Have a good day.
You as well.
Thank you. This is 2402432 LT Tomahawk Ventures versus the occupant. Please state your names for the record.
Good morning, Your Honor. Eric Wine for the plaintiff, P56893.
Mr. User, this is the time to unmute yourself and state your name, sir. You're muted.
Good morning, Ronald James User.
Thank you, Mr. User. Sir, would you like the opportunity to speak to an attorney from Lakeshore Legal Aid this morning?
Yes, ma'am.
Then we'll get you moved into a breakout room with that person. Mr. Wine, do you want to wait around or do you want to take the adjourn date?
Will I be having a hearing because of the court mailing, or are we automatically having a second hearing?
We're going to have a second hearing because by the time Mr. User goes into Lakeshore and they do their intake and advice, it might be a half an hour or so. If you want to wait, you're welcome to. We have a relatively short docket.
All right, I can wait.
Okay.
Thank you.
Sir, you'll see an invitation to go into a breakout room. You'll meet with an attorney from Lakeshore Legal Aid, and we'll figure out from there what happens, okay? This is 2402433LT Huron Estates versus Amanda Atkins. Hearing no response, the court will recall.
Your Honor, I'm sorry. Clifton Hitchcock.
No,
I'm-
2402453LT Farmington versus Anderson. The parties have returned to this main session. Mr. Munson, how are we proceeding?
Yes, Your Honor, I've had an opportunity to speak with Ms. Anderson. At this time, we'd like to record the terms of the consent judgment on the record, please.
Yes, sir.
Yes, sir.
Your Honor, the total of $4,676 will be paid on or before May 17th of this year, or a writ of eviction to issue. Under the court further orders, we're going to split that into two payments. $2,400 will be paid on or before May 3rd, or a writ will issue, and the remaining $2,276 will be paid by May 17th. This is for possession only.
Ms. Anderson, you were able to hear Mr. Munson just now?
Yes, ma'am.
And that's what you wish to agree to?
Yes.
And ma'am, you were present when the video played this morning that explained the rights you had available to you?
Yes.
Do you have any questions about those rights?
No.
Do you have any questions about today's proceedings?
No.
And you're agreeing that a total of $4,676 is due and owing, and you'll pay that at $2,400 on May 3rd, and then $2,276 by May the 17th?
Yes.
And because you've appeared by Zoom, ma'am, have you authorized Mr. Munson to sign your name to that consent judgment?
Yes.
Then he will prepare with a judgment with those terms submitted to the court for entry. Do you have any questions, Ms. Anderson?
No, ma'am.
Anything else, Mr. Munson?
Nothing for me.
Thank you. Ms. Anderson, you're free to go. You have a great afternoon.
Thank you.
Thank
Your
you,
Honor?
Your Honor. Have a nice day.
Okay. Thank
Your
you.
Honor?
I don't
Excuse
know
me.
who that is screaming out in
This
the
is,
courtroom.
I'm sorry, I don't mean to be screaming. This is Clifton Hitchcock, Swiss Stack Levine, on behalf of Huron Estates. I was trying to come on. I wanted to let you know here, I was coming over from the other courtroom at the 34th, and I apologize with Judge Green. But I am here.
Mr. Hitchcock is fine.
Okay, just wanted to
When
let you
people
know.
aren't ready, I just passed the matter, so now I'll come back to you. I'm ready to come back to you if you're
Thank you.
ready.
Just wanted to let you know. Thank you.
Okay, let me just do one. Mr. Callahan only has one case, and I'm not sure Mr. Melville has his hat back on. This is a recall of 2402451LT Redford West versus Ronald Melville. The court has received a notice from Mr. Callahan that this case is being adjourned. Is that your understanding, Mr. Melville?
Uh-oh.
Mr. Melville?
How do I undo this?
Sir, your case is being adjourned to May the 1st at 9:15 a.m.
I
So
can't
that
get
you
it
may have the
unmuted.
opportunity to speak to Lakeshore Legal Aid. Is that how you wish to proceed this morning, sir?
Says you're unmuted. Is she talking to me stuff? Am I unmuted?
I am.
Can you hear, Judge?
I can hear you, Jack. What's going on?
Okay, he thinks that you can't hear him.
I can hear him. I'm asking him questions. Does
I'm
he
sorry.
wish, this case is being adjourned to May the 1st at 9:15 to allow him an opportunity to speak to Lakeshore Legal Aid?
Yes, ma'am. I didn't know you could hear me. I thought it was muted.
No, you're fine.
sorry.
Was there anything else, Mr. Melville?
So that date was Monday, 9:15?
No, May 1st. That's next Wednesday. Next Wednesday.
I'm sorry, at 9:15.
Yes, sir.
May 1st at 9:15. I just want to make sure.
Yes, sir.
I'm so sorry. Look at my hat's off.
You're fine.
May 1st, 9:15. Thank you so much.
Notice will be mailed to you, sir. Have a good day.
You too, ma'am.
Thank you, Judge.
Thank you. 2402433LT Huron Estates versus Amanda Atkins. Is Mr. Hitchcock still in another courtroom? Two four zero two three three eight LT, George Robinson versus Teddy Robinson. Mr.
George Robinson.
Is Teddy Robinson present? Mr. Robinson, today is the day and time scheduled for the first hearing in this case. There is only court mailing. Have you served Mr. Robinson?
Yes,
Did you submit proof of that to the court?
I have proof.
Did you submit proof to the court?
No.
Okay. Then, Mr. Robinson, this case will be adjourned till next Wednesday, May the 1st at 9:15 a.m. You need to submit proof that you've served the defendant of notice to appear.
Okay.
Court sending mail is not sufficient.
Pardon?
The fact that the court served the defendant is not enough. You need to supply the court proof that you've done service as well.
What, do I just turn receipts into the court here?
Yes, sir. There will be somebody at the civil department counter that can help you, but the court will need to adjourn this case to next Wednesday at 9:15, sir.
All right.
Anything else, Mr. Robinson?
No.
Thank you. You can leave out of that door to your left. The court staff will come reset that computer.
Okay.
Thank you. Two four zero one three seven nine Sellers versus Campbell and Campbell.
Yes. Good morning, Your Honor.
State your name for the plaintiff.
Aaron Sellers.
Thank you. And the defendant.
Leonard Campbell.
Thank you. So this case was originally scheduled for last week, April the 17th. The date was changed on one set of paperwork, but not both sets of paperwork. When Mr. Campbell appeared last Wednesday, the court dismissed the case on the plaintiff's failure to appear. I was advised this morning that the case was actually supposed to be adjourned to today. That being the case, would the parties like the opportunity to go into a breakout room to speak this morning?
Yes, ma'am. And
Mr. Sellers?
Your Honor, I would like to also talk to the legal assistants.
Legal aid attorneys. Okay.
Yes.
So let's get you moved in with legal aid, okay?
Okay, ma'am.
Thank you. I saw the message in the Tomahawk Ventures matter. That case will be adjourned to 9:30 next Wednesday. This is 2402432 LT. 9:30 on the May 1st. If there's nothing else, you're free to go, sir. Have a good day.
Was that for me, ma'am?
No, sir.
Okay.
Thank you. This is 2402091 LT, Maxwell versus Frank Rowland. Your appearances, please.
Joe Joseph for plaintiff.
Good morning, Mr. Joseph. I see Mr. Rowland. Frank Rowland. Mr. Joseph, I am sending prompts to Mr. Rowland to unmute and turn his video on. This
Okay.
is a health hazard case. The court's prepared to have a hearing on this matter this morning unless you've reached some other agreement, sir.
We haven't. He's been in the hospital the last 2 times, so unless I can speak with him, I don't have an agreement to report.
I'll have court staff try to continue to get him to connect or to unmute and state his
Okay.
name. Thank you. All of our remaining 9 o'clock cases are with Swistack and Levine. If Mr. Hitchcock is still with Judge Green's office, I just need to have that reported, as there are people waiting here to be seen.
Judge, I was just in Judge Green's courtroom, and he was still working through her docket.
I don't believe that Swistack Levine is a single attorney firm. These cases have been scheduled now for at least 2 weeks. That being the case, I see that the tenants are here and ready for their cases to be called. 2402433 LT, Huron Estates versus Amanda Atkins. Two 2434 LT, Huron Estates versus Holly Agee.
Hello, Holly
State your
Agee.
name, ma'am. Thank you.
Holly Agee.
Ma'am, have you made an Good. Have you made an application for rental assistance?
I have not.
Would you like to speak to an attorney from Lakeshore Legal Aid?
No. Thank you.
Then ma'am, then I'll have you wait until Mr. Hitchcock returns.
Okay.
Thank you.
Thank you.
2402435 LT, Huron Estates versus Sarah Cermak and Austin Gutierrez.
Here. Hello?
Sir,
Yes.
state your name.
Austin Gutierrez.
Sir, have you made an application for rental assistance?
No, I haven't.
Would you like to speak to an attorney from Lakeshore Legal Aid?
Yes, please.
We'll get you moved into the breakout room with them, sir. Your case will be adjourned to May the 1st at 9:30. After you speak to Lakeshore, you're free to go.
Okay, thank you.
I'm sorry, before you go, do you know where Sarah Cermak is? Oh, geez. Are you finished with Judge Green?
I am.
There's, I'm sorry. Sandy, have Mary Ann unlock the room so we can have Ms. Atkins enter. 2402434 Huron Estates versus Agee. Mr. Hitchcock, she's already advised that she does not wish to speak to Lakeshore. She has not made an application for rental assistance.
Okay.
Ma'am, you'll get moved into a breakout room. Mr. Hitchcock will be there shortly to discuss this matter with you.
Thank you.
Certainly. Thank you.
And then 2402435 Huron Estates versus Cermak and Gutierrez. He's gone in to speak to Lakeshore, and that case will be adjourned to May the 1st at 9:30.
Okay.
2402436 LT Huron Estates versus Nicholas Derminer. The case was scheduled at 9 o'clock. It's now 9:39 by this court's clock. There is court mail, and plaintiff post. Defendants failed to appear. How would you like to proceed?
Your Honor, plaintiff respectfully requests entry of a default judgment. There's currently rent to retain possession in the amount of $1,424.82, costs in the amount of $182.68 for a total amount of $1,607.50, which the defendant must pay in full or move out on or before May 6, 2024, or the writ may issue thereafter. No money judgment is sought at this time.
Thank you, sir. Please submit that default by on base. This is 2402439 LT, Huron Estates versus Laura Hart.
Your Honor, Clifton Hitchcock on behalf of the plaintiff, Huron Estates.
This case was scheduled at 9 o'clock, is now 9:40 by this court's clock. Court notes court mail, and plaintiff posting. Laura Hart, defendant having failed to appear. How would you like to proceed?
Your Honor, plaintiff respectfully requests entry of a default judgment. There's currently rent to retain possession in the amount of $1,618.89, costs in the amount of $182.68 for a total amount of $1,801.57, which the defendant must pay in full or move out on or before May 6, 2024. The writ may issue thereafter. No money judgment is sought at this time.
Thank you. Please submit your default through on base 2402440 LT, Huron Estates versus Carol Henderson and Holly Henderson.
Your
Holly
Honor,
Henderson here.
Your Honor, Clifton Hitchcock on behalf of plaintiff Huron Estates.
Thank you. And Ms. Henderson, do you know where Carol Henderson is?
Yeah, she's currently at a doctor's appointment. She just had 3 mini strokes last week.
Thank you, ma'am. Ma'am, have you made an application for rental assistance?
Yes, I have.
Ma'am, you'll need to file with the court a form called a DC 539 if you need help locating that form. Court staff is available to assist you. Would you like to speak to Lakeshore Legal Aid this morning?
No, I'm okay, thank you.
Ma'am, your case will be adjourned to next Wednesday, May the 1st at 9:30 a.m. You have 5 days from today's date to file that form, that DC 539. Do you need assistance in locating that form?
Nope, I already located it. Thank you.
Please do that. Get it filed within the next 5 days. Is there anything else, Ms. Henderson?
Nope, that's all.
Thank you, ma'am. You're free to go. You have a good day.
Thank you, you too.
Thank you. 2402441 LT, Huron Estates versus Lanika Jones.
I'm here.
Ma'am, turn your video on and state your name.
Lanika Jones.
Ms. Jones, have you made an application for rental assistance?
No.
Would you like the opportunity to speak to an attorney from Lakeshore Legal Aid?
No.
Ma'am, you'll get moved into a breakout room. Mr. Hitchcock will be there shortly to discuss your case with you. If you reach a resolution with him, you'll come back here and put it on the record, okay?
Thank you.
Thank you. 2402442 LT, Huron Estates versus Yolanda Kuhlman.
Your Honor, Clifton Hitchcock on behalf of Huron Estates.
This case was scheduled at 9 o'clock. It's now 9:43 by this court's clock. The court notes court mail, and plaintiff posting. Defendant has failed to appear. How would you like to proceed, sir?
Your Honor, plaintiff respectfully requests entry of a default judgment. There's currently rent to retain possession in the amount of $1,304.31, costs in the amount of $182.68, for a total amount of $1,486.99, which defendant must pay in full or move out on or before May 6, 2024, or the writ may issue thereafter. No money judgment is sought at this time.
Thank you, sir. Please submit your default through on base 2402443 LT, Huron Estates versus Angela Longo.
Your Honor, Clifton Hitchcock, Swiss Stack Levine on behalf of the plaintiff.
Angela Longo. This case was scheduled at 9 o'clock. It's now 9:44 by this court's clock. The court notes court mail, and plaintiff posting. The defendant has failed to appear. How would you like to proceed, sir?
Your Honor, plaintiff respectfully requests a default judgment. There's currently rent to retain possession in the amount of $2,629.98, costs in the amount of $182.68, for a total amount of $2,812.66, which the defendant must pay in full or move out on or before May 6, 2024, or the writ may issue thereafter. No money judgment is sought at this time.
Thank you. Please submit your default through on base.
Will do.
Marianne or Sandy, would you please move Mr. Rowland into a breakout room and see if you can get him to turn his audio on and his video?
I've been
Please,
trying,
thank you.
Judge.
He did.
I know, but
Malachi, Malachi said he did get his, he was unmuted. And that's why he threw him back in here, because he got him unmuted. So I don't know if
Thank you.
he's, yeah.
240244 LT Huron Estates versus Darren Maynard.
Morning, Your Honor. Clifton Hitchcock, Swiss Stack Levine on behalf of the plaintiff Huron Estates.
Darren Maynard.
He's here, Judge.
I can see him. Mr. Hitchcock, we'll circle back. We'll see if staff is able to get him to unmute and turn his video on.
Okay.
This is 240244 LT Huron Estates versus Matthew Sandy and Ruth Sandy.
Yes.
Your Honor, Clifton Hitchcock on behalf of Huron Estates.
Mr. Sandy,
Yes.
you need to state your name, sir.
Matthew Sandy.
And sir, do you know where Ruth Sandy is?
She's right here.
right here.
Thank you. Have you made an application for rental assistance?
No.
No, but we'd like to.
Would you like to speak to an attorney from Lakeshore Legal Aid?
Yes.
We'll get you moved into a breakout room with Lakeshore Legal Aid. If you make an application for rental assistance, you will be required to file a form that's called a DC 539. You will need to do that 5 days from today's date. Your case will be adjourned to next Wednesday, May the 1st at 9:30 a.m. After you get done speaking with the representatives from Lakeshore Legal Aid, you are free to leave the session.
Thank you.
Thank you. This is 240244 LT Huron Estates versus Renee St. Pierre.
Your Honor, Clifton Hitchcock, Swiss Stack Levine on behalf of the plaintiff Huron Estates.
Put it in there, but I don't see the docket to write it on.
Renee St. Pierre. Mary Ann, mute yourself, please.
Okay.
This case was scheduled at 9 o'clock. It's now 9:47 a.m. by this court's clock. The court notes court mail, plaintiff posting. The defendant has failed to appear. Mr. Hitchcock, how would you like to proceed, sir?
Your Honor, plaintiff respectfully requests entry of a default judgment. There's rent to retain possession in the amount of $1,654.92, costs in the amount of $182.68, for a total amount of $1,837.60, which defendant must pay in full or move out on or before May 6th, 2024. The writ may issue thereafter. No money judgment is sought at this time.
Thank you, sir. Please submit your default through on base 240244 LT Huron Estates versus Shauna Ruiz.
Your Honor, Clifton Hitchcock, Swiss Stack Levine on behalf of the plaintiff Huron Estates.
This case was scheduled at 9 o'clock. It's now 9:48 by this court's clock. The court notes court mail, plaintiff posting. The defendant has failed to appear. How would you like to proceed?
Your Honor, plaintiff respectfully requests entry of a default judgment against the defendants. There's currently rent to retain possession in the amount of $2,388.14, costs in the amount of $233.71, for a total amount of $2,621.85, which the defendants must pay in full or move out on or before May 6, 2024, or the writ may issue thereafter. No money judgment is sought at this time.
Thank you. Please submit your default through on base. And then there was
Mr. Maynard circle.
Amanda Atkins was admitted. Mr. Hitchcock, if you want to go into your breakout rooms.
Okay, will do. Thank you, Your
I'll
Honor.
see you shortly. Thank you.
Thank you.
This is 240291 LT Maxwell versus Frank Rowland.
Speaking.
State your name for me, sir.
Yes. What can I do?
State your name for me, please, sir. Mr. Rowland, are you able to hear me, sir? Hey, would you have Malachi go in that room with that man for me, please? Thank you. Mr. Rowland,
Yes,
state your name, sir.
Frank Rowland.
Thank you. Mr. Rowland, today is a day and time set for hearing on this health hazard injury to property case. Sir, were you looking to speak to an attorney from Lakeshore Legal Aid this morning, or were you prepared to proceed on your own?
Could you repeat that?
I asked, were
I
you
was-
looking to speak to an attorney from Lakeshore Legal Aid this morning, or were you looking to proceed on your own?
I'll just do it on my own.
Sir, I'm going to have you go into a breakout room with Mr. Joseph. He's the attorney that represents the Maxwell this morning. After you get done
Yeah.
speaking with him, you'll return to this main session, okay?
Okay. Where's the
Thank
breakout
you.
room?
They should move you. Should be able to move you because you don't.
Mr. Maynard? Darren Maynard.
I've been trying, Judge.
I understand. I'm not sure what's going on this morning.
Hello?
Sir,
Yes.
have you heard me calling your case?
Yes, ma'am. I'm trying to figure this Zoom stuff, Your Honor. It's
State your name for me, please.
Darren Maynard.
Mr. Maynard, have you made an application for rental assistance?
No, ma'am.
Would you like to speak to an attorney from Lakeshore Legal Aid this morning?
No, ma'am.
Then, sir, you'll
Yeah.
get moved into a breakout room. I'm sorry?
Yes, I'd like to speak to an attorney. I'm
Then,
sorry,
sir,
Your
we'll
Honor.
move you in to meet with Lakeshore Legal Aid. After you speak to them, you are free to go. Your case is being adjourned to May the 1st at 9:30, okay?
Okay, I'm sorry about the holdup.
No worries, sir. I'm more concerned about being able to see you and you not being able to navigate to this main session. But let's get you moved in with Lakeshore.
Your Honor.
Mr. Sellers?
Hi. My defendant and the defendant, you put into a room to talk to legal aid. I'm just curious, like, what's the next steps? I've heard you say to others that chose legal aid that they would be going till May 1st at 9:30. Is that the case for myself?
It's most likely to be 9:45, Mr. Sellers. I just came back out, saw that they were still in with Lakeshore, was going to say to you, that's likely the best way to proceed this morning.
I can wait if that's possible. But my other question to you is, if he gets legal service, service, I would like legal service as well.
Mr. Sellers, they don't typically take, their office won't be able to represent two sides of a singular case.
Okay. I guess
So
I'm
there's a
also,
conflict of interest. And sir, the court's inclined to adjourn this case because Mr. Campbell was here last week.
I
And if you had
understand that.
appeared, if you had appeared last week and he'd asked to speak to Lakeshore, we'd have adjourned the case 1 week as well. So we are treating today as a first hearing.
I understand. I was there on Monday before our meeting was scheduled and wanted to confirm. That's when they told me in person that it would be on the 24th because they had not had a chance to mail the documents. So it was actually the court that pushed it back and changed my paperwork in person. I don't know how that mistake happened, but ultimately my thought
Mr.
is,
Sellers, no. I'm going to have you stop talking about the case because Mr. Campbell is not out here right now. I understand there are some procedural things that happen here. Hold on one second.
okay.
But I just can't go into the life of the case without Mr. Campbell present. Mr. Joseph, were you ready with Mr. Rowland?
Yes, Judge, we are.
This is 2402091 LT Maxwell versus Frank Rowland.
Joe Joseph for plaintiff.
Mr. Joseph, how are we proceeding this morning?
Judge, we have a consent judgment. This is a termination of tenancy case based on health hazard. I spoke with Mr. Rowland and we've agreed to a vacate date of May 10th. He's given me his consent to sign his name to this agreement. I've gone over his rights under 4.201 regarding the 3-day rescission rule. He understands that May 10th is the date. They could request a writ of eviction as early as the 13th. Unless he has an agreement with management that might extend him beyond that. This is the controlling date.
Thank you. Mr. Rowland, were you able to hear Mr. Joseph just now?
Yeah, I heard it.
And sir, was it your agreement that you would move from the property on or before May 10th, 2024?
Yes.
And Mr. Rowland, were you here when the video played that explained the rights you had available to you this morning?
No, I wasn't here. What was the gist of it? Anyway,
I heard you. Give me 1 second, please, sir. Mr. Rowland, essentially it was that you have the right to hire an attorney, and if you can't pay for one, the court must give you the information about any legal aid assistance there might be in your area. You have the right to have your case heard in the county or district where the property or any part of it is located.
yeah.
You may ask the court to move the case by filing a request or a motion in writing before the court date listed on the summons, or ask the court in person at the first court hearing if you believe that the case has not been filed in the correct court. You have the right to demand a jury trial. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. You may use Form MC-22 jury demand and file it with the court. You must pay a $50 fee when you make your demand or within 5 days of the court explaining the right to a jury trial. You do not have to pay the jury fee if you have asked the court to waive fees and the court has approved your request under MCR 2.002. If your landlord has asked for you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, a federal help or homeless veterans program. You should have received information on local rental and housing assistance with the summons. You do not need a judgment against you to receive help from the places listed above. A copy of the summons and complaint from your case is enough. You may be able to reach an agreement with the landlord by going through a Michigan or local community dispute resolution program. You may find those programs at courts.mi.gov/CDRP. You may be able to reach an agreement with the landlord, that will mean the case gets dismissed. The court must provide you with a form for this or tell you where to find it online. Sir, the court having just read those rights to you, do you have any questions
Yeah.
about today's proceedings, sir?
I understand it.
And sir, you
I
still
have-
wish to sign it, you still wish to have a consent judgment entered that indicates that you will vacate the property by May the 10th.
Thank you.
Sorry. Mr. Rowland,
Yes.
you've agreed to vacate the property by May the 10th, 2024.
What was the date? May what?
May
The
the
10th?
10th. May 10th, yes, sir.
Yeah, I'm prepared to do that.
And you've given Mr. Joseph permission to sign your name to a consent judgment.
He can do that, Joe Joseph.
Anything else, Mr. Rowland?
Your Honor.
You're free to go, sir. You have a good day.
Thanks, Judge. Have a good day. Good to see you.
Good to see you, sir. This is a recall of 2402432LT Tomahawk versus the occupant, Mr. User. You're muted, sir.
Oh,
The
sorry.
attorney from Tomahawk, that's okay. The attorney from Tomahawk has left. Your case is adjourned to May the 1st at 9:30. And notice of that will be mailed to the property, okay?
Okay, thank you.
Thank
Have
you,
a
sir.
good
Have
day,
a
Your
good
Honor.
day.
You too.
Ms. Agee, did you reach some agreement with Mr. Hitchcock?
Yes. He said he would meet me out here.
I saw him come out and then he went back in, so. Who are these people in with Malachi?
That was my question.
I'm gonna jump in there, and.
Thank you.
Yep, you're welcome.
This is 2402433 LT, Huron Estates versus Amanda Atkins. Ma'am, state your name for me, please.
Amanda Atkins.
Ms. Atkins, have you made an application for rental assistance?
Yes.
Have you filed a form that's called a DC 539 with the court?
No.
Ma'am, would you like to speak to Lakeshore Legal Aid this morning?
Yes.
Then ma'am, what will happen is you'll get moved into a breakout room to speak to them. Additionally, you will need to file a form that's called a DC 539 with the court that indicates that you have made an application for rental assistance. That needs to be filed within the next 5 days, and you will need to attach proof that you've made that application for rental assistance. After you get done speaking with Lakeshore Legal Aid, you are free to leave and your case will be adjourned. That new date will be May the 1st at 9:45 a.m. If you need assistance in getting that DC 539 form filed, Lakeshore will be able to give you information, or you may speak to a member of the court staff, okay?
Okay.
Thank you. Mr. Sellers in 240-139, I'm sorry, 1379 LT, Sellers versus Campbell. Sir, this case is going to have to be adjourned. There's a 10 o'clock trial that's scheduled to start. It will be May the 1st at 9:45 a.m. Court staff will mail notice of that new date and time to you at the address we have on record.
All right, thank you, Judge.
Thank you. Ms. Robinson and Ms. Ferguson, 2401879 LT, Geraldine Ferguson versus Jasmine Robinson. State your names
Yes.
for me, please.
Geraldine Ferguson.
Jasmine Robinson.
Thank you. Today is the day and time scheduled for hearing on this termination of tenancy case. Are you both ready to proceed or have you reached an agreement?
We're ready.
Ms. Robinson?
We're ready.
Ms. Robinson, would you like the opportunity to speak to an attorney from Lakeshore Legal Aid?
No.
Ms. Ferguson, do you have all necessary documents and witnesses?
Yes.
Ms. Robinson, do you have all necessary documents and witnesses?
Yes.
Would you please raise your right hands for me, please? Do you swear or affirm that the testimony you give in these matters will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you. May I put your hands down? Ms. Ferguson, this is your case. Please proceed.
Okay. I'm evicting my daughter. We haven't had an agreement. That's pretty much it.
What do you mean you haven't had an agreement? That's pretty much it.
We haven't came up with an agreement of a move out date. This is the second time that I have filed and actually went through with it. The eviction.
Anything else, Ms. Ferguson?
As far as the reasons or anything like that?
It's your case. So I'm just trying to hear the testimony regarding what your case is.
Oh, okay. Well, in that case, my daughter lives with me. and it has been a lot of disrespect. No matter how I try to rectify, it's just been a lot of disrespect, and I just can't take it anymore. I feel like I am a punching
Well, Ms.
bag in my.
Ferguson, let me say this. Don't feel compelled to say something you can't take back, okay?
Absolutely,
Okay.
absolutely.
Was there something else?
No, I was just telling my feelings a little bit because you're a mother, and I'm sure you're a mother, and to have your grown kids in your home disrespecting you, it's not good when you're providing a roof over their head and trying to help them. And I'm just at the point that we just need some space. Her and I have always been there for one another. When she's down, I help. When I'm down, she help, and we're no longer there. And we just need we need space.
Okay. Anything else?
I hope I don't have to say anything else, or I hope
You
not.
don't need to. That's why I said I caution you, don't say something you can't take back.
Okay.
Ms. Robinson, do you have any questions for Ms. Ferguson? Not testimony, but questions.
No.
Thank you. Ms. Ferguson, I have a few questions for you. Is there any written agreement between yourself and Ms. Robinson?
No, ma'am.
How long has she been there?
This is a new house, a new move. So she has been with me since my son was killed. So this is the 4th year. So I think she came after a year after he was murdered. So maybe he was murdered in 2020. So maybe 2021.
Okay. Was there anything else, Ms. Ferguson?
No, I just want a peaceful eviction.
Thank you. Ms. Robinson, your defense to this termination of tenancy case.
I moved in with my mom due to selling my property. I have an 8-year-old daughter. I ended up selling my property to move into another property. The process took a little bit longer. I ended up losing the second property that I was supposed to be moving in. So it caused me to stay a little bit longer with my mother. I stay out the way. I have been trying to get these 90-day late fees off of my credit due to the process of the selling taking longer than expected. I had kept her up to date with my process on basically moving out of her house. But it's been taking me a little bit longer to do so. I asked for time. My daughter is in school. I have been looking for places. I have been getting denied due to having a 90-day late fee on my credit. My bank account was hacked and I am out of money. So I have been trying to basically get that squared away and recover a new job. But things
Ms. Robinson?
Yes.
Respectfully, do you have a defense to this termination case?
What's the defense?
Ms. Ferguson served you with a 30-day notice to quit. They indicated you need to vacate the property within 30 days. You did not do that. She then filed a complaint. That's why we're here this morning. Do you have a defense to her complaint asking that the court order you to vacate the property?
Yes, and my defense is I'm waiting on my worker to help me move. I filed for a SER, emergency assistant, and I was just asking if I can have more time to where my daughter is out of school and I won't be having to figure out anything regarding to my daughter because she's in school over here.
Is there anything else, Ms. Robinson?
No.
Ms. Ferguson, do you have any questions for Ms. Robinson?
Yes. The question that I have is, how much longer are you stating that, because this is the first that I've heard of this, about wanting to wait until my granddaughter is out of school? I
Well, no,
haven't,
Ms. Ferguson, how much time are you willing to allow her?
I wanted her, I just wanted it to be over and I just wanted her gone.
That's not, my question is a number. How many days are you willing to allow Ms. Robinson to remain in the property?
Your Honor, can I? It's just too much.
Ms. Robinson, how many days?
My daughter gets out of school in June. Hold on, I have the date.
Was there anything else, Ms. Robinson?
Nope.
Anything else, Ms. Ferguson?
June?
No, is there anything else, Ms. Ferguson?
No.
The court has heard the testimony of the parties this morning. There is no defense to this termination of tenancy case that the defendant has put forth. That being the case, the court will enter a judgment that the plaintiff, Ms. Ferguson, is entitled to repossession of the property. Judgment is typically 10 days from the date of the hearing. The court will set the vacate date as May the 15th. After hearing, Ms. Ferguson, you'll be responsible for filing a judgment with the court that indicates that the defendant is to vacate the property on or before May 15th, 2024. Is there anything else, Ms. Ferguson?
No.
Anything else, Ms. Robinson?
So I don't understand how you guys could allow someone to be out with their child.
He was quite a jerk on the call. Also,
Ms. Robinson, the thing is, there was a notice. You didn't vacate. She filed a complaint. There is no written agreement between the parties. There's no agreement to allow you to remain in the property. She's allowed to give you 30 days notice to vacate the property. I asked you for your defense and you haven't proffered one. The judgment will indicate that you will need to vacate the property on or before May 15, 2024. If something else happens after entry of the judgment, there's some other agreement that's reached, that's something else. But for today's date, that concludes this hearing.
But in my defense, I did defend myself, so I don't understand.
You did what, ma'am?
You said you gave me a time to defense, and I did. So I don't understand.
That's not a legal defense to the case, ma'am.
What's the legal defense? I have a worker. They're trying to find me somewhere to go. I'm not understanding. It's not like I ignored my mom.
Ms. Robinson, that concludes this case, ma'am. This is a recall of 2402434 LT Huron Estates versus Holly Agee. Mr. Hitchcock, did you reach an agreement with Ms. Agee?
Yes, Your Honor. The parties have agreed to the terms of a consent judgment. There's currently rent to retain possession in the amount of $2,758.88, costs in the amount of $182.68, for a total amount of $2,941.56, which Ms. Agee has agreed to pay in full or move out on or before May 6, 2024, or the writ may issue thereafter. No money judgment is sought. at this time. I've explained Court Rule 4.201J to her, as she's unrepresented by counsel, that she has 3 days, business days from the date of the judgment. If there's anything she should not understand in it, to apply to the court and request that it be set aside. And Ms. Agee has given me permission to sign this judgment on her behalf and submit it to the court.
Thank you. Ms. Agee, were you able to hear Mr. Hitchcock just now?
Yes, ma'am.
And is what he said an accurate statement regarding your conversation and agreement this morning?
Yes.
And ma'am, you were present when the video played that explained the rights you had available to you.
Yes.
Do you have any questions about those rights?
No, ma'am.
Do you have any questions about today's proceedings?
No.
And Mr. Hitchcock's office will prepare a consent judgment with the terms he just placed on the record that indicates that a total of $2,941.56 will be paid, or you will vacate the property by May 6th. Is there anything else in this case, sir?
No, I will submit that today, Your Honor. Thank you.
Thank you. Ma'am, you're free to go. You have a great day.
Thank you.
This is 2402441 LT Huron Estates versus Lanika Jones. The parties have had the opportunity to speak. Mr. Hitchcock, how are we proceeding?
Your Honor, the parties have agreed to the terms of a consent judgment. It's currently rent to retain possession in the amount of $1,654.76, costs in the amount of $182.68, for a total amount of $1,837.44, which the defendant, Ms. Jones, agrees to pay in full or move out on or before May 6th, 2024, or the writ may issue thereafter. No money judgment is sought at this time. I've explained to her rights under the court rule in 4.201J that as she's unrepresented by an attorney, she has up to 3 business days from the date of the judgment. Should there be anything in the judgment she doesn't understand, to approach the court and move to set aside the judgment. And Ms. Jones has granted me permission to sign this consent judgment on her behalf and submit it to the court.
Thank you. Ms. Jones, were you able to hear Mr. Hitchcock just now?
Yes.
Is what he said an accurate statement regarding the agreement you reached with him this morning?
Yes.
And ma'am, you were present when the video played explaining the rights you had available to you?
Yes.
Do you have any questions about those rights?
No.
Do you have any questions about today's proceedings?
No.
And ma'am, you agreed to entry of a consent judgment with a total due of $1,837.44, and that you will pay this amount or vacate the property by May the 6th.
Yes.
Then Mr. Hitchcock's office will prepare a consent judgment with those terms. He'll file it with the court. I will sign it, and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of the plaintiff?
No, thank you, Your Honor.
Anything else, Ms. Jones?
No.
Ma'am, you're free to go. You have a great day.
Your Honor, if I may.
You too.
Ms.
Honor?
Atkins did appear, sir.
I believe I was in the breakout room at the time, so I was asked to join the breakout room, which I did. So I apologize I wasn't back out for Ms. Atkins. I thought she would have been put in the breakout room as well.
She had a problem reconnecting, and this
Okay.
is 2402433. And she's indicated she's made application for rental assistance, so she's been directed to file the DC 539 within the next 5 days. And she was speaking to Lakeshore Legal Aid. So her case, based on those 2 things, was adjourned to May the 1st at 9:45 a.m. And I see Ms.
9:35
Proknick here.
Is this Ms. Pankow's case, Your Honor?
No, it is not. It's
Okay.
not, Tricia.
Not quite yet.
The time on the first, was it 9:35 or 45?
It's 9:45, sir.
4-5. Okay, I got it. Okay, thank you.
Thank you.
And there was one other Huron Estates, and I don't know if it's the same deal with Mr. Maynard. Huron Estates versus Darren Maynard. I don't know if he ended up talking.
He finally did connect, and he went in to speak to Lakeshore,
I thought,
and his case was adjourned to May the 1st at 9:30.
got it. Okay.
And
Thank
sir,
you.
I understand that there's one case left, and I understand that we being court, district court, 34th District Court, we have first and second hearings on the same day. But going forward, if your office is unable to send two attorneys to cover both the courtrooms, if you just let us know,
I will.
then I'll adjust differently. But when I have a screen
Absolutely.
full of your tenants and you're in another courtroom, the court's inclination is to dismiss the cases because I don't make them wait for attorneys, just like I don't make attorneys wait for defendants.
Understand. I'll have that conversation. We were a little short-staffed today with some people out. I appreciate it, Your Honor.
I understand life happens. Do you need to speak to Ms. Prucknick regarding the Pankow matter?
We haven't had a chance to speak, so sure.
If you would just like to adjourn it out a week, we could do that too, whichever is going to be more convenient for you in the court.
Well,
I'm here.
why would we couldn't we do it now? What's the reason, Patricia, for the?
We
Why
can
don't the
discuss it
two
now.
of you, I was gonna say, why don't the two of you go into a breakout room?
Right.
We have another thing scheduled at 11. So whenever you're ready, just let Mary Ann know and I'll come back out.
Will do. Thank you, Your Honor.
Thank you.
Ooh, excuse me. Yeah, Aaron's not in the waiting room no more.
Mr. Campbell, your case has been adjourned to May the 1st at 9:45 a.m. Other than that, sir, you're free to go. I'll see you next Wednesday. This is 2401540 LT West Village Estates versus Joseph Panko and Brittany Panko. Your
Good morning,
appearances.
Your Honor. Clifton Hitchcock, on behalf of West Village Estates.
Patricia Prutnick here on behalf of Brittany Panko.
Thank you. The parties have had the opportunity to speak. How are we proceeding this morning?
Yes, Your Honor. The parties have had a chance. I've had a chance to speak with Ms. Prutnick and Ms. Panko, who she represents. Mr. Panko, she indicated she does not, is seeking assistance from a child protective agency, and the parties jointly request an adjournment of 1 week to May 1st to allot her a little more time in that regard.
That's
Is that
correct,
your
Your Honor.
understanding and agreement? Thank you. Case will be adjourned to May the 1st at 9:45 a.m.
Thank you very much.
Thank you, Your
Was there
Honor.
anything else on behalf of the plaintiff?
No, just as I discussed with Ms. Prutnick, and she confirmed that Ms. Pankow would submit the DC 539 form with the court within 5 days of today.
Thank you. Anything else on behalf of Ms. Pankow?
That's it, Your Honor.
Thank you. That concludes this matter. You're free to go, ma'am. You have a great afternoon.
Thank you. Thank
Thank
you
you,
very
Mr.
much, Your
Hitchcock.
Honor. You have a good day.
day, sir.
Appreciate it. Bye.
Mary Ann,
Yes, ma'am.
our docket is done, so let's stop